Hi folks, you're with us today at your Pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk yet again, and I've done a few over the last week or so, about rape trials and the application of ideological fanaticism into what was once a legal process, but is really no longer, or barely so. There seems to be all across the Western world a very serious attempt, coordinated and happening simultaneously, so it's scripted from the boys downtown, to ramp up the amount of rape trials and the amount of convictions. So I just want to talk sort of a little bit about that, because I think it's not only prevalent now, but I think it'll become more prevalent. There's a real effort, as I say, internationally across the white Western world to bring primarily white people who are accused of rape, men who are accused of rape, to bring white men to trial on the most basic minimal evidence, and to then have effectively a rigged legal process which finds them guilty of some level of misbehaviour, but it allows then the state to put these men in prison. So let's just have a look at the wider issues around that. And as I say, even though I've done a few vids recently, I think it's now, or becoming, and is, such a big issue that it needs more attention and more scrutiny. Now, I'll talk a bit about the legal process. How do you find someone guilty of something when actually they're not guilty of it? And how do you get it into court, bring the matter to court with such a very low burden of proof on the accusation side, but then placing a very high burden of proof and reversing the burden of proof on the accused? So an allegation alone is enough to bring the matter into court. Now, there are various barriers to bringing spurious or low evidence cases to court. Firstly, the police would have to investigate, and they would conclude, well, there's really no evidence here, and the likelihood of it having happened, or having happened as she describes, as being quite minimal or remote. Let's suppose the police believe there is, on balance, enough suspicion to bring a case to excuse me, to court. Then they go to like the district attorney or Department of Prosecutions or some equivalent, depending on where you're at in the world. And then there are various lawyers and alleged legal experts that look at the evidence and say, well, this is going to be a long trial. We don't really have any evidence, so the likelihood of getting conviction is small. Why would we use finite resources, legal resources we have? Why would we use those resources to bring a matter to court where we've got a very limited chance of winning? Because the judge is an independent judge. The judge is only interested in the facts and the evidence that we can produce. The judges isn't interested in ideological fantasy. They're only interested in evidence. But of course, times have changed. Not like that anymore. The police have special, so-called specially trained, which is code for indoctrination, but specially trained, rape experts. Now, these rape experts are not selected from the brightest of the community, far from it. These are quite simple people that are given indoctrination courses. Did you know that 99 out of every 100 women are raped every day, 10 times a day? Did you know that rape is everywhere by Nazis? And that so they're given these courses, one after the other. So they come away thinking, oh, wow, I had no idea. Every woman in the world's getting raped 1 million times over, and by all these straight, white, evil Nazi males. Oh, no, that's really bad. We've got to do something about that. That's right, Shaniqua, and you're at the front line of this fight against fucking Nazi rapists, Shaniqua. You know the power you have, Shaniqua, to put those fucking Nazi men in their place. You thought you had no power? You have the power to get those Nazi men, make sure they go to prison. So Shaniqua runs around and whoa, I'm going to change. What's the power I have? Now, the fact that they've told Shaniqua a whole bunch of lies, and she's gone through a radical indoctrination process, all funded by the taxpayer, that's by the by. Shaniqua's out there now looking for all these rapes, because they're everywhere. under the bed, in the closet, floating in a coffee cup. They are everywhere. And there's only two types of men who rape and get away with it, and men who are brought to justice. Justice is what we want for these Nazis. So then we've got the same sort of thing, in almost a mirror image, happening in the Department of Prosecution. Some very low level, IQ 90 type people, mostly women, but not all. Gay men and people who are victims and oppressed by society, who want to get back at society. Vengeance is on their mind. That's what they want. And vengeance against who? Well, Nazis. Vengeance against, well, who are the Nazis? People that commit the rape. And rape and Nazi, it's just a miasma of rapists and Nazis everywhere. And they're in the Department of Prosecutions now. They're district attorney's officers, so they get the ticker box sort of sign off to, let's take this to court. But there's no evidence. Who cares? Ideologically, the guy's guilty. Whether he did it or not? So, okay. Now, of course, there was another layer of protection where there'd be a judge interested in evidence and facts and this sort of thing, but that's disappearing as well. The chances are very high now that you can get a activist judge, maybe someone who was, employed in an NGO who was pushing rape propaganda. Maybe it was a former, lawyer, activist lawyer in the DA's office who specialised in finding rape perpetrators everywhere you look. Maybe they're now a judge, because the bar, you don't have to be an expert in law to get a gig on the bench these days. But being an activist is far more likely to get you a gig, in my opinion. So the chances are you can get an activist judge. So all the barriers to bringing a spurious, low evidence case to court have effectively disappeared now. So it's very easy to bring a case to court. And then once it gets to court, and I'd like to sort of bring up at this stage the Trump case in New York recently, where E. Jean Carroll was had alleged that Trump had behaved inappropriately, 25, 30 years ago or something like that with her, and was able to bring a case in a very activist, anti-Trump area and district. And it was able to go through it's a civil case, but to go through all the sort of what otherwise would have been safeguards to prevent spurious, vexatious, or sometimes they call it, cases coming to court. Now, something I'll point out here that's critical. Okay, so you bring a flaky, low, case to court, you don't really have much of a chance of winning. So you look at the evidence put forward by the straight white male, and you look at the woman's case, or the supposed ideological victim's case, and you look, and her case is quite weak. She's not going to win. So as the judge, the activist judge, you have to make sure that she wins, because you're applying ideological law here. You're not applying the law or fact or evidence, you're applying ideological law. So there are still discretionary areas the judge has in order to affect the outcome. So let's suppose that, for example now, let's suppose that the woman that's bringing the case has actually made a million claims like this previously, and they've all been turned down in the courts and so on. So it's not feasible that someone could bring that many claims in that many cases. So straight away you're dealing with a very unreliable claimant here. So you would say, well, I'm not going to hear this case. The evidence is so minimal. It's so long ago. It's unlikely in the extreme based on balance of probability. So I'm going to dismiss the case. That would be your typical legal outcome. But we're not talking legal here. We're talking ideological. Well, she's a victim. He's the oppressor. So I have to rig the evidence, the judge says. I have to rig the evidence to make sure that her weak case is made stronger and his strong case is made weaker. So how will I do that? Well, I'll just take out the part where he's saying that she's brought a million cases, false claims in the past. I'll just delete that from the evidence. So, no, you're not allowed to mention that in court. I'm just going to cross that out. You've got here that she, she's done this and that, and that she spent, years in psychiatric care. You're going to, I'll take all that out. You're not allowed to say that. You're not allowed to mention that. You've got here proof that she's made many hundreds of false statements and so on and so on. I'm going to take that out. You're not allowed to say that. Now, where she says, I heard someone say that somebody said that someone overheard somebody said that he did this, not evidence at all. It's passed through several pairs of hearsay hands. I'm going to let that stay in, and I'm going to treat that as evidence. I'm going to treat that as fact, which you have to deny. So by doing this sort of thing, by reversing the burden of proof and saying, well, she can say anything, she's allowed to, she's the ideological victim, but any facts you bring to refute it, I'll refuse that. I won't allow those in the court. I won't allow you to use that as evidence. Anything that undermines, her integrity, or claims of integrity, anything that undermines the veracity of her claims, anything that proves that you didn't do it or you weren't there, I will disallow all of that evidence. And so the only evidence remaining is her allegation, and I will treat that allegation as fact. You can't deny it. You can't disprove it because I've disallowed all the evidence you had to disprove it. Therefore, you are guilty. So this is a device that you see used in ideological courts. It used to be, not used, it's common practice in divorce courts. And I've seen it. I was watching a case in a divorce court where the evidence against the woman was quite damning, but the judge just disallowed all of it. And the evidence supporting the man was quite concrete, well backed up by witnesses and affidavits and so on, facts. So the judge just disallowed that. So on the balance, therefore, she wins because he's got no evidence. Why has he got no evidence? Well, the judge just disallowed it all. So these sort of things. Now that could be appealed, and somebody with the wealth of Mr. Trump can appeal that. But for the vast majority of the population, they haven't got the resources to appeal that. If the judge suspects that they may appeal it, then he can simply make a full costs order against them, so that they're bankrupted by the process, and therefore they have no resources to make an appeal. So these are the devices that activist judges use to produce outcomes that are consistent with ideology. And we're seeing that particularly in rape cases now, where or it's inappropriate sexual behaviour cases, where the evidence that quite strong factual evidence that supports the man's position or the accused's position, the straight white male, is just simply disallowed by the judge. Now, there's nothing you can really do about that unless you have the resources to appeal it. And the judge already knows when you walk into the court what your resources are. Is it an expensive lawyer? Is it a cheap lawyer? Does someone have a well-paying job? Or so, and so on. So already a judge can make a pretty accurate assessment as to whether or not someone has the financial resources to appeal it. And if they don't, and manifestly don't, then the judge can really do what they want, whatever they want, and just dismiss and disallow evidence or refuse to, and also reverse the burden of proof and do things that are really quite illegal in a court of law, not a court of ideology, but a court of law. The judge is deviating substantially from proper due legal process procedure. But unless you've got the funds to appeal it, there's not much you can do. That's just how it is, and you have to live with it. Which means in most of these rape trials, the judge, the ideological type structure of the court can get away with playing their little games of childish fantasy. Now there was another case sort of recently where the guy was got a term in prison. There's various grades of rape now, such as unwanted, sexual acts, and there's some other names here. And I actually wrote a few of them down, so I'll just refer to that. Sex without consent is another one. This is a bit of a favourite one at the moment. Now, what that means is that the legal definition of consent is a technical matter. Again, and I've mentioned this in other emails, if she's had 2 glasses of wine, she can still give consent. But if she's had 2 glasses of wine plus 1 mouthful of wine, then she cannot give consent. So even though she gave consent, she can't give what's called informed consent. This is a technical legal term, and therefore it is rape. One mouthful of wine less, not rape. 1 mouthful of wine more, it is rape. Now, the difference is that in these, they're almost civil cases in a lot of ways, but they have a civil burden of proof, so they can bring the matter to court with what's referred to as a balance of probability burden of proof, which is quite a low burden of proof, particularly when you're looking at it ideologically. So they can drag something into court on an allegation alone using civil standards of proof. But when they reach a determination, they can then turn around and issue criminal court penalties. So civil case rather, standards of proof to bring the matter into court, but then criminal penalties when they've decided they've got the person nailed. Now, this perverse attachment of civil burden of proof to criminal penalties is a fucking outrage, and it's used widely now, not only in rape courts but elsewhere, or even in divorce courts. There's one case where it was alleged that his ex-wife alleged that he had a motorbike that was no longer there, and therefore he'd sold it. So the court ordered, well, you have to say how much you got for the motorbike. And the guy was like, what motorbike? And so you can't believe this happens, but the judge decided to just arbitrarily arrest and detain the guy in prison until he said how much money he got for a motorbike. I mean, you've got to be fucking kidding me, right? But this is the level of ideology that's applied. Well, she's a victim and you're an oppressor. You fucking Nazi! I'm putting you in prison. And this is the ideological sort of nature of the practice of law that has come out of the divorce court type ideological courts and into now all courts. Anything where there's supposed to be sort of conflict between, in an ideological sense, between sort of genders or races or anything like that is now ideological. Facts, evidence, be fucked. It's gone. So here's a case where a guy got, I think it's 4 or 5 years in jail, but he, so he's at some party somewhere. Some woman has said that invited him over for the purposes of sexual gratification. So I want you to come over and fuck me. Okay, so. He's running late at this party, so he calls her and says, look, I'm running late, do you want to call it off? And no, she wants him to come over. She wants to be fucked, and she wants him to come over. So he does. So he comes over. He gets there, and she's either changed her mind or whatever. So for approximately 30 seconds, he attempts to get her to change her mind back again. Not violence or threat of violence, but I mean, he's a pretty big guy and she's pretty small now. So he attempts to, get her more excited and horny and so on, which was not inappropriate under those circumstances. But she then decides that she's going to say that he attempted to, acted inappropriately and tried to coerce her into having sex and managed to get him dragged in the court. Now, it just so happens he's quite a well-known sports star. So these are also scalps that the ideological fanatics want to go after. If it's not just a classic straight white middle-class male, then a sports star is also a great trophy to have. And so they went after this with a vengeance. The guy got prison for it. Now, I've got a few issues with this. Not that he should have forced himself on her, by the way, but nonetheless, she makes it clear she wants, I want you to fuck me. I want you to come over and fuck me now. This sort of stuff. So the invitation is quite explicit. There's not like there's ambiguity in this. He gets there after being specifically invited. He's given her the option to pass up on the opportunity, but instead she insists, no, come over. And then when he gets there, and he's gone out of his way to get there, she changes her mind. Now she would, he quite reasonably say, hey, hold on a minute, last time I spoke to you on the phone, you're all good to go. Now you've changed your mind after I've come over. So, that he would make an effort to encourage her to engage in intimate act. That's not inappropriate under the circumstances. that he only did it for an alleged 30 seconds suggests that he when she kept on saying no, they go, oh, okay then, and off he went. There was no violence or threat of violence. Now, some of the arguments put in, well, she's only tiny. She's only 5 foot tall, 149 centimeters tall, and she only weighs, 50 kilograms or 100 or so pounds. So she's tiny. You're 6'2" and you weigh over 200 pounds, over 100 kilograms. So because of that power imbalance, you were threatening by your mere presence and your size, and because you're so much bigger than her, and therefore that makes you a threatening presence. It therefore makes you a danger. It therefore causes fear. Therefore you are a fucking Nazi. So that's this ideology playing in, this victim ideology of oppressor and oppressed. Doesn't matter whether the guy weighs 3 million kilograms or she weighs 1 kilogram. That's not the material point here. That gets ginned up as an expression of oppression by the Nazis. Then that's ideological, and any judge that allows that isn't a judge, in my opinion. They're just another ideological fanatic that's there to produce ideological outcomes. Now, this could be looked at both ways. Billie Jean. So you get often the idea of guys who are 2 or 3 times your size fucking you, do you? I mean, is that you like that, really big guys? So you specifically target big guys who are much bigger than you. You specifically invite them over to fuck you. Why don't you invite over a guy who's smaller and lighter than you? Why don't you invite over a guy who's half your height and half your weight? Why don't you invite those men over? Why must yours invite men who are much bigger and then complain you're a victim? Well, how can you be both? Why do you want? I mean, do you get off on the power of controlling such a big guy, watching him grovel to get sex from you? Is that what you like? Is that so you could switch it around? Like if we're in the realms of ideology alone and not facts, then you could switch it around and say, well, hold on, you're the criminal here. Why did you invite somebody over who was that much bigger than you? Why did you say you wanted this big guy to come over and fuck you? Why did you do that? You are contributing to the outcome here. Why are you claiming now that you're a victim because the level of control you thought you had wasn't, you miss, and so on. So you could go into a whole number of it, but the predetermination is victim and oppressor. Therefore, there's no other conclusion can be reached within the ideology that he's guilty, you're a victim. So the burden of proof she needs to meet is very low because she's already the victim ideologically and he's already the oppressor ideologically. So he can't prove his innocence. He can prove maybe that he wasn't there, or he could prove that he was in another country at the time. Those sorts of things are still facts. But anything other than that, if he was in the same room at the same time, then ideologically he's already guilty, and he needs to have some, because it's still a he said she said thing. He needs to prove that he can't meet that burden of proof. She no longer has to prove. She only has to prove that he was there, and if he can't prove he wasn't there, then that's it. He's effectively guilty. So, but you're so much bigger than her, you therefore must be guilty. And now you can look at the he said she said thing. Should he have even for 30 seconds, encouraged or attempted to encourage her to change her mind? That's not necessarily unreasonable under the circumstance that she specifically invited him there, come over and fuck me. He gives her the option of changing, saying, well, look, I'm running late. You still want to do this? And she insists she does. So I wouldn't think that him coming over or his effort to get her to change her mind was unreasonable under those circumstances. When you strip away the circumstances and the realities and just go ideologically, then you big strong man, a little tiny woman, you fucking oppressor, Nazi, guilty. And that's pretty much how the case went. And the guy got a prison term. Now, again, I've got this problem of a civil matter being transformed into a criminal matter. Civil levels of burden of proof, which are the lowest levels, as if you were just going to get a fine or something like that, but then attaching a criminal penalty to the outcome. I've got a real problem with that. And I think we really need as a society to take a look at that, because we've allowed, and our body politic and our entire legal establishment has allowed this ideology to creep in all across the Western world. And it's happened simultaneously, with the same ideology driving it in every country. So clearly it's scripted from a central point downtown, and we've allowed that to be taken over. And it is the most diabolical thing, in my view, where ideology has replaced facts, it's replaced reality, and it's replaced guilt, as in as soon as the guy gets accused, and an allegation lands enough, he's effectively guilty and must disprove his guilt. Now, if the burden of proof to bring the guy into court was high and the burden of proof was reversed, that would be different. But then it does need to be high. So if you're going to say to somebody, you have to prove your innocence, because we say you're guilty, but we don't have to meet any decent burden of proof to determine or allege that you're guilty, then that's one thing. And then the other 5-card trick of using, again, as I've mentioned a few times now, using civil entry point into the legal system, but having a criminal outcome. These things really have to be addressed, and I think we all need to be very concerned by it. You've been a Tacitus today at your Pushback channel. Thank you for listening.